Good evening. I'm not going to mention any names. While I am not under a court order to not mention any names, I just thought I would express that it is probably not a good idea to make a video about someone if you're under a court order to not do such things, especially if you are going out of your way to make it patently obvious who you're talking about. Now, I am making this video because sometimes some people get a little bit butthurt when they make the wrong decisions. And never can it be said that I follow the common ideology that the enemy of my enemy is my friend. The way I see it, people do right, people do wrong. Someone who does right today may do wrong tomorrow, and vice versa. I'm not here to try to prop up anybody. I am here to point out truth, justice in the American way. So if someone goes to court, let's say just, randomly, let's say on a civil restraining order that is found in, let's say, a state's domestic violence restraining order types of laws, and yet has an application for non-domestic violence situations where 2 or more acts of stalking have occurred. Let's say that they go to court on that because they have been they are now the restrained person in a temporary restraining order or an emergency protective order. And they have all the facts on their side, and they have all the law on their side. And their lawyer, who they have crowdfunded, has even told them that they have the facts and the law on their side. But let's say that they are brave Sir Robin. And let's say that brave Sir Robin is told that, yes, there is a chance that you might lose. There is always a chance you might lose. There's nothing guaranteed in the law. And brave Sir Robin says, well, what will we do if I lose? And the lawyer will say, well, then we'll appeal it because you should win. I can't guarantee you will win, but you should win. And if you don't win, there is a real serious problem. If the judge ignores the facts and the law, then we should appeal it. And the judge can get in some very serious trouble if he ignores the facts and the law. So we should be okay. But brave Sir Robin is not very brave at all. And he says, you know what? I just want to get this done. Is there any way we can resolve this so I don't have to give up my sword? I like being a knight. It scares me to not be a knight. And I would rather lose my voice than my sword. And so the attorney takes brave Sir Robin's note, his offer of surrender, the terms by which brave Sir Robin will surrender to the opposing knight, we'll call him, or her, who knows. And they work out a mutually agreeable surrender for brave Sir Robin. And now brave Sir Robin is mad because brave Sir Robin doesn't think he got justice. But brave Sir Robin never went out there to fight. How can brave Sir Robin get justice unless he enters that arena of combat, does his trial by combat to figure out who God is granting justice to? So who denied brave Sir Robin justice? Was it anybody besides brave Sir Robin? I don't think so. I think brave Sir Robin ran away. Now that we've talked about brave Sir Robin, let's talk about assault. We know it's not battery. We know that if somebody drives up on you really fast and then slams on their brakes and applies their horn as they're screeching to a stop. We know that's not battery unless they actually hit you. If they don't hit you, it's not battery. It's not battery. Battery, they got to hit you. But it could be assault. You say it could be assault. And if we were looking at the crime of assault, yeah, it sure could be. It could also be the tort of assault. But let's look at the crime first. And let's see why I said go for the tort. Sue him, her, whatever. For the tort of assault, don't try to force the district attorney to bring a criminal charge under the crime of assault. And the place that I love to go to figure out what you're really dealing with in a criminal case is go to the jury instructions. The jury instructions are amazing because they break it down for you. And they break it down for you in a way that a juror could understand. And so somewhere in here it says that's assault and battery elements. God damn it. Simple assault. Here we go. Oklahoma defines assault in accordance with both of the common law definitions. All right, so it's just common law, basic MBE assault. An attempt to commit battery, that's one way of doing it. Did she try to batter him? You could say probably not. Probably not. Because there were brakes being applied. There was a horn being applied. Probably not an attempt to batter. The other thing is the intentional placing of another in apprehension of receiving an immediate battery. That's more possible. Intentional placing of another. That means that she's trying to make him in apprehension of being battered. So he thought he was going to be battered. So that's easy. I mean, he was in apprehension of being battered, but she intended to do it. And that's the stickier of the two wickets. You see, proving intent, since intent is an element of the crime, to prove intent for a crime, you have to prove the intent beyond a reasonable doubt. And there were brakes being applied, and there was a horn being blown. And those things are contradictory evidence to an intent to place another in apprehension of receiving an immediate battery. The brakes were locked up. The horn was being blown. It appears, just from a cursory glance of the evidence, that a jury could determine that they cannot decide beyond a reasonable doubt. They can't believe beyond a reasonable doubt that she was trying to place him in immediate harm or immediate apprehension of immediate battery, into apprehension of immediate battery. They can't prove that beyond a reasonable doubt. Now, they probably could prove it by a preponderance of the evidence, which is a much lower standard of proof. Where do you use preponderance of the evidence? You use that in a civil case, like if you were suing someone for the tort of assault, which is why somebody, and I can't mention any names because we're not playing the name game, somebody said from the get-go that maybe a suit for assault would be a good way to go. Crimes are harder to prove. I know all of you desperately want to think that the system is rigged. But here, let's look at the facts. The facts are that a DA was presented with evidence. With this evidence of somebody who some of you hate, some of you love, driving up fast on somebody that some of you hate and some of you love, blowing the horn, screeching the brakes. And the DA looked at that, and the DA came to a decision that would defend, or that would not charge, I should say, somebody that some of you love and some of you hate. Does that make the DA for the suspect? Does that make the DA against the suspect? That's weird. You know, I never can understand the bias that everybody else seems to think that the criminal justice system has. Because who should the DA be biased against here? The DA has an actual obligation. The DA is not allowed to bring any charge that the DA doesn't think is supported by probable cause. That's number one. And number two is the DA is not supposed to bring any charge that the DA doesn't think they could win on. Well, there's a humdinger, isn't it? So is the DA not bringing this particular action because the DA is in the pocket of this particular person? I mean, that makes you feel better, right? It makes you feel all warm and fuzzy. But you know that I'm not a fan of the driver of the vehicle. I have been a vocal critic of the driver of the vehicle, and I've been a supporter of the person, the brave Sir Robin, who bravely ran away. And yet here I am, all neutral, saying that no, bringing an assault case is a criminal assault case is probably not a winner. I mean, maybe you could convince a jury, but it's probably not a winner. It's probably not a winner, especially since you have video of horns blowing and brakes being locked up. So think about that, and think again, all of you who are convinced that the system is biased against the defendant or the suspect. Think about that again. Try real hard to come up with a good argument, still lacking citations, as to why the system is biased against the suspect or the defendant. And remember, if you want to complain about not getting justice, make sure that you aren't the person who prevented you from receiving justice. Thanks for watching. Have a great evening.